This is the recorded lecture for Chapter 7, Civil and Administrative Law. So far, our study of law is focused on criminal justice, due process, and the rule of law. This chapter takes us into the counterpart of criminal law, civil law. By the end of your study of this chapter, you should be able to compare and contrast criminal and civil law. Identify and describe the different categories of civil law and the characteristics of each. Understand and explain the legal, sociological, and political aspects of administrative law. And then apply those concepts to the financial crisis of 2008 or to environmental regulation. And last, describe and give examples of each of these concepts: compensatory versus punitive damages, preponderance of the evidence versus beyond a reasonable doubt, tort law, negligence, contributory and comparative negligence, the Uniform Commercial Code, family law, administrative law, the Administrative Procedures Act, and Chevron deference. The textbook's introduction to Chapter 7 does a really great job of explaining the role that civil law plays in our society. I couldn't have said it any better, so I'm just going to read it, and you can follow along on page 169 of your textbook. So far, we have concentrated on law and justice as they pertain to criminal matters. But social justice requires that the law also concern itself with other harmful or potentially harmful acts that society has seen fit to regulate, but that are outside the purview of the criminal justice system. And looking at the slide here, this is our bullseye again from when we talked about crimes. And you can see that there is a specific ring there. It's the second one in from the edge, where all social harm is indicated. So this is harms that are not regulated by criminal law, but instead by private law that regulates social behavior between private citizens. Law is not only about redressing harms already done, it is also about trying to prevent them and to ensure fairness and predictability in everyday life. Law provides rules about how individuals, agencies, and corporations should conduct themselves. Law protects individuals and society from harmful things such as defective products and polluted air and water. Law tells us how to conduct business. It monitors the contractual promises we make. It regulates business practices. It tells us who we may or may not marry, who gets what if the marriage breaks up, and myriad other things, all of which fall under the broad umbrella of civil law. Whereas public law involves the regulation of various relationships between and among government and non-governmental entities, such as corporations and private individuals, civil law is private law, and it governs transactions between non-governmental entities. So that last sentence that I just read tells you in a nutshell the distinction between civil and criminal law. Whereas public law involves the regulation of relationships between the government and citizens, civil law is private law. It governs transactions between private citizens. So I guess I'm putting it a little bit differently, but that's it in a nutshell there. Now, the best way to understand this new concept of civil law that we're introducing is to compare and contrast it with what you already know about criminal law. So I'm going to show you a chart here that compares and contrasts civil and criminal law. And this is an important chart. You should study it carefully. And it's going to be spread between these two slides. So I'm going to go through a series of these questions that are answered here on this slide, On one side of the slide is criminal law, and then on the other is civil law. So these are the answers to the questions from here pertaining to criminal and civil law. First, who are the parties and who is the victim? So in a criminal law matter, the parties are the government represented by a prosecutor versus a private citizen. So a defendant. You have a government versus a defendant. In civil law, the parties are a private citizen versus another private citizen, and they're called plaintiff and defendant. So even in civil law, the government or a government agency can be a party to a civil lawsuit, but the remedy would not include any loss of liberty. So it's sort of different. But most of the time in civil law, you've got private citizen versus private citizen. The next question is, what does the initiating party seek to accomplish? What specific remedy is sought? So in criminal law, the initiating party is the government, and they seek punishment. They want the defendant to go to jail, pay a fine, get probation, some sort of deprivation of freedom or liberty. That's what is the specific remedy that is sought. But in civil law, the specific remedy sought is money. Sometimes it's the performance or non-performance of an act. Typically, the award in the civil law case is compensation, a monetary award known as compensatory damages. And they are for the harm caused by the defendant. Usually you can look at it like restitution. We'll talk about restitution a little bit more in chapter 9, but this is a form of restitution, compensatory damages, payment for the harm caused. The point, though, is to return the victim or the plaintiff to status quo ex ante, which just means back the way they were before anything happened, back in the position in which they began. It is often accomplished through reimbursement of medical expenses, pain and suffering, and sometimes can include actions, defendant having to do something or not do something, or to transfer property. Now, you can also have a separate monetary award called punitive damages. Punitive damages are not measured directly by the harm the plaintiff was caused, but instead by what it would take to punish the defendant for the behavior. So private law can actually exact a punishment at the hands of private citizens, only it's a monetary punishment. And in order to receive a monetary punitive award, the defendant's behavior must be particularly egregious, and usually a higher level of proof is required to establish that that behavior has occurred and punitive damages are justified. The standard is often called clear and convincing evidence. So it's different than criminal law, but it's still higher than your typical civil law standard of review, which we'll get to in just a second. So the next question is, who bears the burden of proof? And you all better know, after having studied criminal law, that is the government. The prosecution bears the burden of proof because they're seeking to deprive an individual of his or her freedom. And the defendant, as you know, doesn't have to present any evidence at all unless he or she wishes to assert an affirmative defense. Now, very different. In civil law, both parties share the burden. The burden will shift from one side to the other. It usually starts with the plaintiff. The plaintiff is the one who is initiating the cause of action, filing the complaint. And the plaintiff has to make what's known as a prima facie case. Prima facie, I think it means like first on its face or something, but it's just they have to present evidence of their claim. And once they present evidence of their claim, the defendant must answer that claim. This is a very different situation from criminal law. If a defendant does not answer a claim, the defendant loses. So the defendant has to appear and answer the claim and present evidence to counter it, to defend himself or herself against the civil claim. The next question, as I kind of alluded to a second ago, is, so what is the standard of proof for each party? And as you ought to know, in criminal law, the government has to prove the defendant's guilt beyond a reasonable doubt. So it's not absolute certainty, but without any real reason to doubt the defendant's guilt. It's a very high standard, the highest of all, because loss of life and liberty is at stake. In civil law, it's much lower. The standard for a plaintiff or for anyone bringing a claim is the preponderance of the evidence. More likely than not, the defendant acted wrongfully. And it's a lower standard because there's no loss of liberty at stake. It's just all about money. The next question is, does the defendant have Fourth, Fifth, or Sixth Amendment rights? Well, of course, in criminal law, absolutely. That's what we spent a whole chapter talking about. In civil law, though, the answer is sort of. So the Fourth, Fifth, and Sixth Amendments don't apply. You're not involved in a criminal matter where you're about to lose your life or liberty or property. But there are still procedures in place to ensure basic fairness, to ensure that the evidence presented to the jury is reliable, to ensure that the jury's verdict is reasonable. But those procedures aren't exactly the same. So, for example, in a civil case, you can't plead the Fifth Amendment. If you do that, you can still get a civil verdict against you. Whereas in criminal cases, of course, you assert the Fifth, you don't have to testify, but that doesn't work in civil law. And what in reality happens, though, is a judge will typically just stay the civil case. Like if there's a criminal case and a civil case going on simultaneously about the same matter, the same factual situation, the judge is going to hold the civil case, like hold it in abeyance until the criminal matter is settled or resolved in some way, and then allow the civil case to go forward. Because the Fifth Amendment's not going to protect the defendant in the civil case, that's the other option. So you can see that there's still procedures in place to ensure this fairness, but it's different than just having the Fourth, Fifth, or Sixth Amendment rights to assert. Next question, who can appeal? Well, we know in criminal law, it's just the defendant. Only the defendant can appeal an adverse verdict. But in civil law, either party can appeal. So let's say the plaintiff sued the defendant and asked the jury to award them $50,000. And guess what? They win the case. The jury says, we find in favor of the plaintiff. But they only award the plaintiff $10,000. Well, the plaintiff can still appeal. The plaintiff can appeal even the amount of damage that's enough. So either party can assert some sort of legal error made during the trial and ask the appellate court to change it. So the last question I have on here is one of the most important, and that's what we're going to be talking about for the rest of this course. What is the purpose of all this anyway? What's the purpose generally? So we know in criminal law, the purpose is essentially to control harmful behavior, to regulate society so that we don't hurt one another, and also so that our individual rights are protected. The same is true in civil law. And you may not recognize it immediately, but hopefully by the end of this chapter, you'll get it. For both criminal and civil law, the purpose is regulating human conduct so that the members of society can exist together in a peaceable, orderly fashion. And this is also called social control. And you're going to hear me say that a lot over the next few chapters. social control. That is the whole point. We want predictability in our economic transactions, and we want justice when someone is harmed. And also, I want you to keep in mind, the same harmful behavior can be the subject of both a criminal and a civil case. And in fact, the victim of a crime often brings a civil lawsuit against the defendant and may win a monetary award, even if the defendant is not found guilty of the crime. An example of that you may recall or not, maybe you saw the movie, was O.J. Simpson. So the prosecution lost in their prosecution of him, but the family of, I've forgotten her name, his ex-wife, Nicole Simpson, well, they won their civil suit against him. But it was all based on the same thing, the death of Nicole Simpson. So now we're going to talk about the specific types of civil law. Like criminal law, civil law has different types or categories. So we have in criminal law, crimes against the person, crimes against property, crimes against public or moral order. In civil law, we have these types or categories. Tort law, which regulates behavior that causes physical or emotional harm. Property law, which regulates the ownership, possession, and use of property. Contract law, which regulates business or economic transactions. Family law, which, as you might assume, regulates familial relationships. And last on here is administrative law, which is really a hybrid of public and private law. It's regulating private conduct that causes public harm or harm to the state or society as a whole. I believe the textbook might also mention juvenile law, but I disagree. It does not fit very well in the private law category. It just doesn't. We're going to look at it separately when we cover Chapter 8. It isn't exactly the same as standard criminal law, but it fits better there. So I'm just going to leave that one out for now. All right, contract law. All right, contract law regulates economic transactions between private parties. There will be a contract. Oh, well, let me start back just a little bit. A transaction, when I use the word transaction, I'm referring to the exchange of money for goods or services or some combination of goods and services. So there's some sort of economic transaction, and there will be a contract that sets the terms of the exchange or transaction, and it should represent the parties' common understanding for what will be exchanged and when and where and how. Contract law contributes to social order or control because it offers predictable enforcement of these private economic transactions. The common law of contracts is pretty much the same no matter where you go. We need predictability nationwide. So that's why I have on this slide that contract law is very common law, because commercial transactions cross state lines. There's got to be some uniformity and predictability that goes wherever you travel in the U.S. So now let's look more specifically at contract law. As I said a minute ago, contract law regulates economic transactions between private parties. But there's kind of two types of contract law. There's law that pertains to non-sales, so not selling goods, some other type of contractual relationship. And then you have contract law that pertains specifically to the sale of goods. So when the transaction involves the sale of goods between merchants, the law is so uniform that it has been codified into statutory law, something called the Uniform Commercial Code. Every state in the U.S. has adopted the Uniform Commercial Code in more or less identical form. It's so uniform. I mean, it's so common that the whole nation kind of has its own statutory law that governs the sale of goods. And that should come as no surprise because goods travel across state lines all the time. Contracts now, let's look at them specifically. Contracts set the terms of the economic transaction. I mentioned that a second ago. But before a contract can even be enforced, it has to have certain elements. And mind you, being written is not one of them. A contract does not have to be in writing to be enforceable. There are a few exceptions to that rule, but by and large, they don't have to be in writing. They usually are, but they don't have to be. What you have to have are these three things: a meeting of the minds, reliance or consideration. Those two words are used interchangeably, and legality. So I'll go through what those mean. When I'm talking about a meeting of the minds, I'm talking about the terms of the transaction. Both parties have to have the same idea, the same terms in mind. So there'll be an offer with certain terms or of certain terms, and acceptance of those terms. Both the offer and the acceptance must come in good faith, so nobody's trying to scam anybody, and they must be given voluntarily. Both parties must knowingly enter into the contract. So once you have a meeting of the minds, then comes reliance or consideration. One or more of the parties must take some action in reliance upon the performance by the other party. So someone steps out and takes the risk that the other party is going to act on the terms that they've agreed upon. And last, the contract has to be legal. And all we're talking about there is that both parties have to be of age, right? They have to both be adults. You're not going to be able to enforce a contract for the sale of crack cocaine. I mean, that's not a legal subject. So that's what I mean when I say legality. So once you have a contract with all of those three parts at play, then you've got an enforceable contract and both parties have to perform it. When one party to the transaction does not follow through, he or she has breached the contract, and the other party can sue to either specifically enforce the contract or to be compensated in some other way. And the award is typically, it's similar to the other types of civil law. It's to restore the plaintiff to the status quo ex ante, meaning to the way they were before the contract began. So it's usually through money or compensation. It can be through the specific performance of a court ordering the other party to follow through. I have attached a link in this slide to a video clip from the movie The Paper Chase. I don't know if you've seen it. It's kind of old, from the 70s. But this movie is about a young man's first year of law school at Harvard University. And in the clip, the young man is asked, it's like his first day of law school, first year, first day, and he's in class, and he's asked to deliver a case brief. So the case brief is just like what you guys have been doing with your case summaries of Brewer versus Williams and Loving versus Virginia. It's the same thing, only it's orally. He's asked, and this is what would happen to you if you go to law school, you're asked to brief a case, to summarize a case. And he's asked to summarize the case of Hawkins versus McGee. Hawkins versus McGee is the seminal breach of contract case that every law student will learn on their very first day of contract law. And it's also known as the hairy hand case. So you can watch this clip from The Paper Chase here to see an example of the elements of a contract, its breach, and how the damages are determined. I'm just going to cross my fingers and hope that this works.
Mr. Hart, will you recite the facts of Hawkins versus McGee? I do have your name right. You are Mr. Hart.
Yes, my name is Hart.
You're not speaking loud enough, Mr. Hart. You speak up.
Yes, my name is Hart.
Mr. Hart, you're still not speaking loud enough. You stand. Now that you're on your feet, Mr. Hart, maybe the class will be able to understand you. You are on your feet?
Yes, I'm on my feet.
Loudly, Mr. Hart. Fill this room with your intelligence. Now, you give us the facts of the case.
I haven't read the case.
Class assignments for the first day are posted on the bulletin boards in Langdale and Austin halls. You must have known that.
No.
You assumed that this first class would be a lecture, an introduction to the course.
Yes, sir.
Never assume anything in my classroom. Mr. Hart, I will myself give you the facts of the case. Hawkins versus McGee is a case in contract law, subject of our study. The boy burned his hand by touching an electric wire. A doctor who was anxious to experiment in skin grafting asked to operate on the hand, guaranteeing that he would restore it 100%. He took a piece of skin from the boy's chest and grafted it onto the unfortunate boy's hand. The operation failed to produce a healthy hand. Instead, it produced a hairy hand not only burned, but covered with dense, matted hair. Mr. Hart, what damages do you think the doctor should pay? What did the doctor promise?
There was a promise to fix the hand back to the way it was before it was burned.
And the result of the operation?
The hand was much worse than before he went to the doctor.
How should the court measure the damages? What should the doctor pay the boy?
The doctor should pay for what he did, and he should pay for the difference between what the boy had, a burned hand, and what the doctor gave him, a burned and hairy hand.
Mr. Pruitt.
Well, I hope that never happens to you guys. Law school isn't quite that intense. But this is an example here of a contract case. It was actually treated like a breach of warranty case. It was established and enforceable. Nobody was disputing the existence of the contract. There was definitely a meeting of the minds, reliance, and legality. The doctor offered to provide or to restore the boy's hand 100%. Okay, he warranted that in exchange for money. His offer was accepted voluntarily by the boy's father. It was voluntarily entered into in good faith. Both parties intended to perform. The dad paid, the surgery was performed, so there was a legal contract between two adults. The contract was breached because he did not get a good hand. It was not restored 100%. He got a hairy hand. And so what was promised certainly was not delivered. And the whole case hinges then on damages. The clip doesn't really say it, but because that young man was not prepared for class. But the result was that the damages were valued at the difference between the value of what was promised and what was delivered. And that's typically the compensatory award in a breach of contract case. All right, next is property law. And as you might expect from its name, property law is law that regulates behavior regarding a person's right to use, possess, or own property. It offers predictability to transactions that specifically involve property, different kinds of property, real property, which is land, and personal property, and intellectual property. Now, there are different types of interests or rights that a person may have in the property, and they're listed in your textbook. Don't stress out too much about trying to memorize all these different types of interests, but just generally know that there are different types of interests that people can have, different types of interest in real property, such as whether it's freehold or non-freehold, whether it's a fee simple interest or a fee simple absolute, whether you own it as joint tenants or tenants in common. Then there's also property rights known as an easement, where you aren't really gonna live on the land, but you get the right to use part of it for a specific purpose. If you own a home, the utility companies have an easement interest in your property, in your real estate, to run their power lines or water lines or gas lines or fiber optic cable, through your yard. That's an easement right. A person can have air rights or subsurface rights, like mining rights in property. There's something, and this is real, squatters' rights. That's a real thing. It's also known as adverse possession. When someone uses property for a significant period of time, even though someone else owns it, if that owner doesn't interfere and sort of assert himself or herself, well, that person who's been using the property has possessory rights to it after a significant period of time, mind you. There are also bailment interests. So say you take your clothes to the dry cleaner. Well, the dry cleaner then has a property interest in your coat or dress. It's very limited. It's just for the specific purpose of cleaning it, but they do have some responsibility for it. Intellectual property is a very different and separate type of property law. It has its own federal court system, actually, and it's just property interest in ideas. It's pretty cool, but it's also very specific. It's something that would be covered in a different class. Now, before you think that property law is boring, I want you to take a look at that picture on the slide. This is a photo of a house in New York State called the Nyack House. It's a real place. You might have heard of it. It is a famous house because it was, believe it or not, legally declared haunted in the case of Stambovsky versus Ackley. I'll read just a couple of excerpts from the case so you can see a little bit of property law in action here. So this is Jeffrey Stambovsky versus Helen Ackley. The plaintiff, to his horror, discovered that the house he had recently contracted to purchase was widely reputed to be possessed by poltergeists, reportedly seen by the defendant's seller and members of her family on numerous occasions over the last 9 years. Plaintiff, this Mr. Jeff Stambovsky, promptly commenced this action seeking rescission of the contract of sale. So he's trying to kind of unwind or undo the contract to sell the house to him. The Supreme Court in New York, the Supreme Court is actually the Intermediate Appellate Court. So the Intermediate Appellate Court reluctantly dismissed the complaint, holding that the plaintiff has no remedy at law. I want you to catch that. Remember, we learned about the difference between courts of equity and courts at law. He's asking for a legal remedy, and the Intermediate Appellate Court said he couldn't have it. So the unusual facts of this case, as discussed in the record, clearly warrant a grant of equitable relief to the buyer. He was a resident of New York City, cannot be expected to have had any familiarity with the folklore of the village of Nyack. Not being a local, plaintiff could not readily learn that the home he had contracted to purchase is haunted. Whether the source of the spectral apparitions seen by the defendant's seller are parapsychic or psychogenic, having reported their presence in both a national publication known as Reader's Digest and the local press, the defendant's seller is estopped to deny their existence, and as a matter of law, the house is haunted. More to the point, however, no divination is required to conclude that it is defendant's promotional efforts in publicizing her close encounters with these spirits, which fostered the home's reputation in the community. I'll skip down just a little bit. The impact of the reputation thus created goes to the very essence of the bargain between the parties, greatly impairing both the value of the property and its potential for resale. While I agree with the Supreme Court that the real estate broker as agent for the seller is under no duty to disclose to a potential buyer the phantasmal reputation of the premises, and that in his pursuit of a legal remedy for fraud against the seller, the plaintiff hasn't a ghost of a chance, I am nevertheless moved by the spirit of equity to allow the buyer to seek rescission of the contract of sale and recover his down payment. So that's what happens, folks. If you sell a house and you know it's haunted, you got to tell the person buying it from you that it's haunted. That's a real property law case from New York in 1991. Oddly enough, that house is still in existence and it is used as the set for several movies. All right, next, family law. As you might expect, family law regulates family relationships, marriage, divorce, and adoption. It provides social control because these relationships are the scaffolding of American society. We have laws to support and uphold families because they in turn offer stability and order to society. Family law is conciliatory law, not accusatory. You'll learn more about those words when we get to chapter 9. But the goal of family law is to do the least amount of harm possible. It is focused on the entering into and dissolution of marriages and families. A marriage is actually a contract to which the state is a party, because marriage brings along with it certain civil rights and responsibilities. It affects taxes, whether they're jointly filed or not, and different rules apply depending upon your marriage. It affects property law. If you think about the property interest that two spouses might have in the home. And of course, it affects children and their health and education. So the state is involved in the marriage to that limited degree. And as a result, the state has a regulatory power over the marriage and family. Because marriage is a contract, it has certain legal requirements, such as age requirements, competency requirements, blood tests. There's some state-to-state variation, but there are regulations covering marriage that are actually constitutional, that aren't a violation of rights. But marriage and family are fundamental rights. And by virtue of substantive due process under the Constitution, the right to marry is essential to the liberty of any human being. And the state, the same is true for raising your children. So the state cannot infringe upon that right completely. There can be some minor little regulations pertaining to how old you have to be when you get married or such. But the larger issues of who you marry is a fundamental right that the state can't regulate. All right, next, and I think, our next to last type of law is tort law. Tort law is law that regulates behavior that may or has caused personal non-economic harm. It is focused on the risk of injury to a person and seeks to reduce that risk and deter conduct that might create it. So the specific purpose of a tort case is to restore the plaintiff, the injured party, to status quo ex ante. All right, so it's restitution. The individual case is about the restitution for an individual private citizen. But civil remedies have a collective effect that benefits society as a whole. So in the aggregate, altogether, tort awards create a deterrent to behavior that presents an unreasonable risk of injury. In the aggregate, tort law is a mechanism of social control. If a company can expect to be sued by multiple plaintiffs for some product or service that it's not providing in a safe way, well, that company is going to change its practices. It's going to conform. An example you might have heard of in more recent years is the Takata airbags. That was a big products liability tort case involving airbags that were installed in motor vehicles that would explode, and different mechanical parts would come flying out of it and people would be severely injured. There were nicotine lawsuits, cigarettes. That was a big deal. Public policy changed regarding cigarettes because of the harm that was caused, and companies stopped making it or reduced their production of it, but mostly started applying very strict warning labels on cigarettes. Those are just a couple of examples of when, in the aggregate, a whole lot of tort law cases created this incentive for a company to change its behavior. So in that sense, tort law has controlled the behavior of society, or for members of society. A tort, just so you know, a tort is an odd little word, but all it means is harmful conduct that is not criminal. That's all it is. Harmful conduct that is not criminal. That's that private social harm. There can be an overlap in the actus reus element of a crime. So that actus reus element, that act, it could be a crime, but it can also be a tort. It can be the subject of a civil lawsuit. So there is a little overlap there. And there are essential elements that must be established by the evidence before a plaintiff may recover damages. That's similar to the 5 elements of criminal liability. And we'll go through one of those on the next slide. First, here's some categories of torts. So like just like there are various types of crimes against the person, there are various types of torts you can have, and levels of mens rea. You might see these here. An intentional tort could be assault. That little acronym IIED, intentional infliction of emotional distress. So the harm could be physical or emotional, and you can recover damages for its intentional conduct. Battery, libel, slander, trespass. Those are some other intentional torts. The main one, though, that you see a lot of is negligence. So a negligence is a tort. It means the breach of a duty of care that factually and legally causes harm to another. And I've listed there are 4 essential elements of the tort of negligence. There must exist a duty of care that is breached and that factually and legally causes harm to an individual or group of individuals, and that harm could be physical or mental. And then you also have strict liability torts. There aren't many of them, but there are a few. It's when the plaintiff is injured by the defendant's conduct, and regardless of whether the defendant intended it or was negligent, it doesn't matter. If the plaintiff is injured by the defendant's conduct, the defendant loses. So really the causation becomes the biggest dispute there. But like I said, this doesn't happen very often. It usually involves very dangerous products like guns, for example. And some, I think also maybe some pharmaceutical drugs also could be the subject of strict liability. I'm not sure about that though. Crimes, there are defenses to tort actions. I've listed contributory and comparative negligence. So contributory negligence is when a defendant says, well, guess what? The plaintiff contributed to his or her harm. They did something stupid that actually caused their harm, and therefore they lose, and I don't have to pay because they were really the one who caused their own harm. Then there's comparative negligence, which is where a jury gets to weigh who was the most wrong. So the plaintiff might have done something dumb, but the defendant might have been negligent too. And so they kind of split the difference and award a lower damages award just to take into account the effect that the plaintiff's own stupidity had to causing the harm that they suffered. And then there are also similar like criminal defenses or defenses you probably heard with in connection with crimes. A plaintiff can just say, guess what? One of these elements here is missing. I didn't know you a duty, or I didn't cause your harm, or you weren't really harmed. Those sorts of things. You can argue that you were justified for your tortious conduct or excused somehow. There are similar defenses there. All right, tort reform. And this is something I really want you to pay a close attention to. Because of your interest in law, taking this course, you may have heard stories about huge awards from the victims of tortious behavior. The textbook lists some examples of it, such as it talks about a plaintiff who sued McDonald's because her coffee was too hot when she spilled it in her lap. You've probably seen commercials for plaintiff's attorneys where they have these testimonials of clients receiving these huge verdicts, huge awards for some type of car accident. Some people see these big verdicts as justice. Like, for example, if you saw the movie about Erin Brockovich, who helped a group of plaintiffs win a case against, she called it PG&E, it was Pacific Gas and Electric Company, for contaminating the drinking water in their community. The verdict there was like $333 million that went to the plaintiffs. And on top of that, the company wound up having to pay all of these costs to clean up the property. So it was a huge case. And you may look at these cases and think, well, great. That's justice for the little guy. Well done. We like this. Or you may look at them and just sort of roll your eyes and say, just the attorneys are getting rich here and businesses are going bankrupt. So to you, it's not justice, it's jackpot justice, huge windfalls to undeserving attorneys or plaintiffs and some sort of unfair redistribution of wealth. Now, there have been efforts through both the judicial and legal process to tamp down on these windfall awards. Those efforts are known as tort reform. This type of reform could be common case law that just places legal restrictions on the recovery of punitive damage. Let me just give you an example of that. So I practice law in Alabama, and in Alabama, the law was that a punitive damages award would be measured at 3 times the compensatory award. So if a plaintiff won $50,000 as compensation for their medical expenses and pain of suffering, the punitive damages award couldn't be much more than $150,000, 3 times that $50,000 verdict. Otherwise, it might be considered an unjust award and be reversed. So that's just an effort at proportionality that was accomplished by the court system. And it's not just in Alabama, it's other states too. But some states actually have legislation that places a cap or maximum amount of punitive damages that can be awarded to a plaintiff. Some tort reform legislation imposes certain evidentiary burdens on the plaintiffs who sue providers of necessary services like doctors and nurses. There are myriad ways that tort reform can be accomplished. But really, the question is, and what I'm presenting up here for you is, do we even want it? Is tort reform good for America or not? So perhaps we want the social control that big tort verdicts provide. Perhaps we don't. And I've listed here some reasons for or against it. I'm going to start with against it. So if you are against tort reform, here's the reasons why you might be, oh, excuse me, I've kind of misstated it. When I say against, I mean you're against big verdicts. So I'm sorry if that's confusing. Where I say against, I'm talking about you're against having these big verdicts and you want there to be reform. And the reason for that might be that the cost, those big verdicts, those dollars, that's passed down to consumers. The decision makers in the company that is sued, they don't lose their jobs. And because of the type of business organization they have, they don't pay the damages out of their own pockets. Instead, the overall company pays the damages and then raises the costs of the goods that they produce, often necessary consumer goods, to offset the loss. Sometimes the company will fire employees in order to recover that loss. So in the end, the bad actors are never actually punished by the big verdict. So that's why I guess it's getting a little confusing, but that may be why you think that torts or big verdicts are wrong, that they're ineffective. Another reason might be the standard of proof in a civil trial. It's lower, right? We talked about it. It's preponderance of the evidence, more likely than not. So you have this lower standard of evidence or proof, but the impact can result in just as great a loss to the defendant as a criminal verdict would. It can put a small business into bankruptcy. I actually saw that happen in my own practice. It creates this incentive for businesses to leave a jurisdiction where large verdicts are awarded. So if a company knows, well, if we move and situate our business in this county, well, this county has a reputation for awarding these billion-dollar judgments against companies like us. Oh, we're not going to go and operate our business in that community because we don't want to get sued there. Well, that company could be a provider of very important goods and services as the community wants, but they can't have it because there have been these huge verdicts. So it kind of takes away access to some important goods and services that people in the community may want. So in that sense, we don't like the large trial tort verdicts. Also, you might look at it as just a get-rich scheme for lawyers, or you might consider it bad policy because it very literally does involve the redistribution of wealth outside of the democratic process. So those are all reasons why you are against these huge tort verdicts and in favor of some sort of reform. I'm sorry that's kind of confusing on the slide. I hope I'm making it clear here. So we're going to flip to the other side here. Why might we like these large verdicts? Well, for one reason, it's accountability. Corporations make huge profits, and that they allow their shareholders to get very, very rich. You might think of Jeff Bezos as an example. So billionaires are made from these corporate businesses, these companies, and they get rich by providing goods and services. And sometimes those goods and services turn out to present an unreasonable risk of injury to the public. So shouldn't they be the ones held responsible for having cared more about their bottom line than they do about human life? So in that sense, you see the good that comes from these huge verdicts. You want to hold companies accountable for taking risks. An example of that is seen in your textbook on the very beginning, page 168, the story about the Pinto, the Ford Pinto, and how the Ford Motor Company made the decision to manufacture this vehicle that was extremely dangerous. So it was just this complete disregard for the harm that their vehicle could make, but they knew that the cost to fix it would outweigh the cost of lawsuits. And so they chose not to fix it and just let people get hurt and sue them. And it completely backfired on them, thankfully. But unfortunately, a lot of people died because of that decision, and Ford Motor Company was held responsible for it. So another reason why you might like these big verdicts, well, it gives people, the little guy, the average citizen, a louder voice. So legislators, as you know, government regulators, so people passing laws and such, they answer to lobbyists oftentimes and to special interests, large groups, often trade groups that are are formed by these companies. But in lawsuits, people are exerting their control and their influence and controlling the behavior of the company. So it's giving them a voice that they wouldn't normally have through government regulation. Next, keep in mind that corporations are business entities. They can't be put in jail, but tort awards, large awards, can punish them anyway through their pocketbook, through their profit loss. Also, the awards that you hear about, or the ones you hear in the news anyway, those jackpot justice windfalls, those are usually just anecdotes. It doesn't really happen that often, if ever, really. It's just you hear about it because it's shocking and provocative and makes you pay attention to the news. They don't really happen that often. And when they do happen, there may be good reason for it. The textbook offers some good statistics on that might affect your opinion, so you should read it. It's on page 176 through 177. And last, then, sometimes private regulation of social behavior, so private lawsuits, are actually more efficient than government regulation. So that's your alternative. Either we're going to have some sort of social control through government, or we're going to have it through private citizens. And sometimes private citizens are a lot more efficient about accomplishing that. There's a whole lot less taxpayer expense involved when you're just using a tort lawsuit. So there are good reasons for and good reasons against tort reform. Tort law can be a good mechanism for social control, and it's just really a matter of weighing the pros and cons. All right, so the last type of law we're going to talk about here is administrative law. So we're ending with it because administrative law is really a hybrid of private and public law. It's private law in the sense that it applies to private business transactions, and it is enacted, enforced, and adjudicated by private citizens, non-elected officials, non-government officials, well, semi-government officials. But so you've got that hybrid of the parties there, or private parties there. It's public in the sense that the rules, the regulatory laws, come from a democratic-like process. I'll explain it in just a minute. And the goal of that process is to carry out public policy. The officials, these semi-government officials, are appointed to their position by the president or Congress. So they're semi-public officials. The budget for government regulations and regulators, these agencies' budgets, come from our tax dollars, from public money. They are publicly funded organizations. And so they operate to enforce public policy with public money. That's how they're kind of semi-public, semi-private. Administrative law is very, very detailed and specific. It's often written by scientists, not lawyers, not legislators. So that makes it unique. Administrative law, it is written, enforced, and adjudicated by administrative agencies. There are a whole lot of them. You look at that little picture on the slide that just kind of shows you the seal or logo of several agencies of the federal government. There are over 400 administrative agencies in our country, and that's a lot. And I'm going to explain to you why there are so many now. Before the Civil War, there were only 11 administrative agencies in the United States. But before the Civil War, we were a much different country. We were much smaller. And it was before the Industrial Revolution got big, got really big. It's really at the second Industrial Revolution where this all changed in the late 1880s. Industry got big, and it got big fast, not just with population growth, though that was a very large part of it. America became a world power and a big player in the world economy. Think about the international trade of goods, the oil magnates, the steel magnates, agriculture, coal, railroads, all of these industries boomed, and all of their employees, let me start. The people who started these companies got really, really rich, and they had investors who took a risk with them to start these companies. And their concern then was to see that those investors got a return on their investment. They were far less concerned about their laborers. So this is also a time of immigration. Many of the laborers were immigrants. Many of them were very, very poor, and they were easy to forget. So the big company owners who were making all the decisions, the big decision makers, well, they were accountable to their corporate investors, but not to their laborers, not to their employees. And the law at this time, in the late 1800s, was always on the side of business. It was laissez-faire economics. Business had never really been a threat to society, and we wanted our country's economy to grow and thrive. We wanted to keep up with England and France and Italy and all the European countries. So we were just allowing businesses free, unfettered range, just go, build, employ, make money, build our country for us. But that changed when businesses got so big that they stopped caring about the impact their choices were having on their employees and on their consumers. The public was suffering because of labor exploitation, because of unsafe working conditions, unclean environments where our food was prepared. You can think of the book, The Jungle by Upton Sinclair. It was written around this time. You can think about child labor, which I've depicted in this slide. Those are real pictures of laborers that worked in some of, I believe, coal mines. The top picture, 154 killed in a skyscraper factory fire. Scores burned, others leaped to their death. That's the Triangle Shirtwaist Factory fire in New York. Many, many women worked there in this textile business, and the owners of it thought the women were stealing from them. So they locked them in during their workday. Well, because of this unrestrained, unregulated business activity, there weren't any regulations to maintain the safety of the facility. A fire caught on, a big one. The women were trapped inside and they burned to death, or they jumped out of the window to try to avoid being burned to death. It was a terrible situation, and it was a direct result of not having enough government regulation to maintain safe learning conditions. So that triggered a shift in public policy in America. We had to change and create incentives for the companies to be safe, to care again about their employees and consumers of their goods. And that's where administrative agencies came into play. There was explosive growth in the agencies that began with the New Deal legislation under Franklin Delano Roosevelt. This was around the 1930s. And also at this same time, the Supreme Court began to interpret constitutional provisions regarding the power of federal government in a different way. You may recall this, or you better recall this, that substantive due process. That's when this started happening, where the court begins focusing more on the protection of individual rights, the rights of laborers, the rights of individual citizens and consumers. So all that kind of contributed together to give us those 400 agencies, and it's not necessarily a bad thing. So what do administrative agencies do? Well, it all starts out with public policy. Elected representatives in Congress would hear from their constituents that there's a need for regulation of a particular business activity. So they enact legislation that reflects that policy. But oftentimes, the regulation requires very detailed, precise, technical rules, which the congressmen and women are not equipped to write. So they must delegate that job to experts. This is known as the delegation doctrine or the non-delegation doctrine. Congress is authorized to delegate its lawmaking power to an agency, provided that certain conditions are met. So those conditions are a little beyond the scope of this course, but essentially they are meant to ensure that the agencies do not operate without some measure of oversight or control by Congress. To combat criticism about the means by which agencies were operating, Congress passed something called the Administrative Procedures Act. The Administrative Procedures Act, or the APA, outlines the rules by which agencies may pass regulations, police and enforce their compliance, and even adjudicate the violation of the rules. So it governs, then the APA governs all three functions that agencies perform. They perform all three government functions: lawmaking, law enforcement, and law adjudication. It's kind of like an agency is its own little three-branch government, quasi-government. They have a legislative function where they make regulations that are then recorded in the Code of Federal Regulations that become statutory law. They will investigate and enforce. So that's sort of your executive branch there. They're enforcing their own rules. They usually send inspectors out to check for compliance. Companies have to file reports with administrative agencies to show their compliance with the regulations. And then there's also a judicial function to an administrative agency. Violations of regulations are first handled in-house by the agency. And like an agency representative, some inspector finds a violation and they report the company to the agency, and the agency holds an adjudicatory hearing. There will be a judge called an administrative law judge who will receive evidence. There's no jury. They'll receive evidence from both the accused company offending the rules and the agent or agency. They will evaluate that evidence, look at their regulations, and decide whether there's been a violation. And the APA, the Administrative Procedures Act, has the procedures for doing all of those judicial things. The loser, before the agency can appeal to and bring it into the civil court system, but civil courts will give great discretion to the administrative law judge because the administrative judge has the expertise that's needed for this situation. So they just look for some sort of abuse of power, an obvious misinterpretation of the law, some arbitrariness. And if they don't see that, then they're going to defer to whatever the administrative law judge has said. It's known as Chevron deference because that's the name of the case that set the precedent for giving that type of deference, Chevron deference. They're just going to defer to what the administrative law judge said as long as he or she has been reasonable in their interpretation of it. The remedy for violating an administrative rule or regulation are usually just fines. Administrative courts aren't part of the criminal justice system, so the offenders don't go to jail. But if an agency investigation yields discovery of what should be criminal conduct, and it's not just a rule violation, it will turn over the evidence to the Justice Department for prosecution by the federal government, usually the FBI, the IRS, or some other federal criminal agency. But that didn't happen very often. And you got to think, so what's the cost of all of that? The cost of an agency's investigation and enforcement, does it justify what they've done? I don't know. That's kind of where you go back to the debate between what's better, private regulation of this behavior or public government regulation of behavior. And that kind of goes back to the pro and con list we saw earlier. Now, your textbook at this point covers in several pages at the end of chapter 7 examples of government regulation in the banking and finance industry, the 2008 sort of meltdown of the banking industry. And then there's a section on environmental legislation. I don't have time in this shortened course to go through all of that. It's actually one area I know quite a bit about because I lived through it and worked in it. But I just don't have time to go into it all. What I'm going to do is just encourage you to really read those sections of your textbook more than once. You can go on the internet and Google I think it's called The Meltdown. There's a PBS documentary about it. You can go and there's a really great movie and a book. It's called A Civil Action with John Travolta is the main actor in it. That's a great example of the investigation of a environmental law violation. And there it's conducted kind of in a dual situation between private citizens and the EPA. And it's interesting to see who's more successful, the EPA or the lawyer who brought the lawsuit. But I'm just going to have to leave you to read that. I don't have time to get into it. So now you can just proceed to take the quiz on chapter 7.